record button. Thank you. Thank you. Yes, it is. So I'll give a little background for both Pam and Heidi. So Pam is an owner and president of OccuScreen LLC, which is an employment screening company located in Vancouver. We help employers nationwide actually make informed hiring decisions by providing FCRA compliant background checks, verifications, and drug testing services. Pam has served on the Portland Human Resource Management Association Board of Directors for more than 10 years and was president in 2015. She also volunteers with Dave's Killer Bread Second Chance Foundation. Heidi, who is our other presenter, Heidi Mason, pronouns she, her, hers, represents public and private organizations in employment and labor law matters. Prior to becoming an attorney, Heidi worked as a human resources professional for mid-sized and large corporations. She has hands-on experience in recruitment and selection, compensation and benefits, employee and labor relations, occupational safety, leaves of absence, payroll, and ensuring compliance with applicable laws, regulations, and collective bargaining agreements. Heidi earned her bachelor's degrees in human resources and general management from PSU, go Vikes, and her JD cum laude from Lewis and Clark College, Northwestern School of Law. And she's also PHR and SHRM CP certified. So I think we are ready to kick it off here. So I will start by asking the question. So what is reasonable suspicion and how does it differ from probable cause?
All right, looks like that one's mine. Before I answer the question, I'm going to do Pam's favorite thing and give my attorney disclaimer. I am a lawyer. I am not your lawyer. So I can't give you any specific legal advice, but I can definitely share some general principles and best practices and things like that. And if you have a specific situation as we get later on in the presentation that you want to talk about, best way to ask me the question is, hey, Heidi, hypothetically, if like XYZ happened, what do you think about that situation? And I am more than happy to answer those kinds of questions, right? Now, once in a while, I'll be in a presentation where my client is actually in the room. And if that was the case, I would say, pretend like you're not and give me a hypothetical question and preserve the attorney-client privilege. So second thing, as you probably noticed, I also don't talk like a lawyer because I hate legalese. It just doesn't do anybody any good. And I only use it if I have to because it's court. So otherwise, you can expect plain language for the most part from me today. All right, so question, what is reasonable suspicion? How does that differ from probable cause? So we're going to start with reasonable suspicion or reasonable grounds. It's all in the name. You have a reason to believe that somebody that works for you is impaired while they're at work, right? That's really it. You have some ground, some basis to believe that that's what's happening. Probable cause, forget it. Probable cause is a standard used in criminal law. You're not law enforcement. You're not going to arrest anybody. You don't need to worry about that standard. It just does not apply to you as a private employer. As a private employer, all you need to do, for the most part, like in Oregon at least, right? Other states might be a little bit different on where they set the standard, but you've got to have a reasonable basis in fact to believe this person is impaired. So what does that kind of look like? Well, I've got an employee. They show up to work and their speech is slurred, and I can smell alcohol on their breath. And I can actually smell it like emanating from their body because it's coming out of their pores, right? Yeah, I have reasonable grounds to believe this person is impaired right at work. I have another employee maybe, and they come to work and they're acting weird. Like I have to ask them the same simple sentence 3 or 4 times in a row, and they're still not responding very well. And at the same time, they're tearing off pieces of paper and eating it. Yes, I think something's wrong. I think that they might be impaired, right? There could be a whole bunch of different factors, but the key is whatever it is that you notice, can you articulate what it is? And can you tie that to a belief that that might be because of drugs or alcohol? that's what you're going for. If it's just, oh, this person's performance has decreased, then my question would be, how are you going to tie that to drugs or alcohol? Because that could be any number of reasons why their performance is bad. Maybe they're just flaking out on you today. Maybe they're tired, right? Maybe it's drugs, but how are you going to tie that somewhat closer to drugs or alcohol specifically? The more factors you can articulate, the closer you are. It's not a bright line standard. And the good news is you just have to be reasonable about it. It's all in the name, right? If you're reasonable about it, you're really not going to get a whole lot of pushback in terms of like legal enforcement or any kind of claim. You just have to be able to articulate exactly what it is.
Can I throw in a question that I get all the time? If I have a suspicion about someone, and maybe it was just a rumor, maybe I haven't seen anything happening per se, but someone told me that they thought maybe someone was doing something, can I throw them into my next random test group?
Great question. No, because that's not random anymore. That's called rigging. Don't rig your random tests, right? Now, could you alternatively take that person's report and use that as the basis for a reasonable grounds test? Maybe you can, right? How strong and how credible is the report? And we'll give a couple of examples. Let's say that the person who is making this report has been with the company for 10 years and they have a history of being a great employee, a very honest employee, a very dedicated employee, and somebody who knows everybody. And they come forward and they're obviously distressed. And they're telling you, hey, I really had a hard time coming to this decision, but I need to let you know that my best friend who also works with the company, they're really struggling with a heroin addiction. And they've talked to me in private about it. And I've been to their house. I've seen them when they've been strung out and high. And I know that they're using right before they come to work. Yeah, I'm going to accept that as reasonable grounds to move forward with a drug test because I've got a credible employee. I have no reason to believe they're lying. They have direct firsthand knowledge of what's going on. And they have a relationship with the person they're reporting. Good enough for me. But if I have a supervisor come to me and say, hey, I heard our new person that we just hired that passed their drug test is actually, high on pot when he's coming to work. And I asked the supervisor, have you noticed anything interesting or different about their behavior? Well, no. Have you smelled anything? No. Well, where did you hear about it? Just on the floor. People were talking about it. Who was talking about it? People. No, that's not good enough. I need something more specific than that, right? No firsthand knowledge, no relationship, no personal observation. I'm not going to accept that.
Right. Another question is, so luckily, I think we're all Oregon employers at this point. Is that right? Okay. Is there a threshold, Heidi, that is, state to state? Can it vary greatly? I mean, obviously the guidance is always know what your state allows. So is there anything that you can share with regard to, thresholds by state as far as reasonable suspicion?
So I don't know about other states outside of Oregon. In Oregon, kind of what we've been talking about here, where you need just that reasonable basis, that's going to be good enough. Okay. If you are operating in other states, generally most states are similar, but there always could be nuances. If you've got a specific special situation, get on the phone with counsel for that state and they can guide you there.
Yeah.
And I did look a little bit into this before, excuse me. And it looks like pretty much across the board, as long as you, and I shouldn't say across the board, always check, but across the board that reasonable suspicion testing is possible in every state as long as it's part of your policy. Sometimes there are a few changes on differences on how you can test. And so that's something else to think about. And mostly now, especially with oral fluids now being part of the federal program, mostly it's more about whether or not you can collect on site or not. It doesn't really matter if it's a urine or an oral fluids. It just matters if you can collect on site. In Oregon, that's not an issue. You can collect on site and you can use any of those. And we'll talk more about the different types of testing in our next week. But
Great.
I see a question in the chat.
Okay.
Regarding reasonable suspicion, how many opportunities do they get to improve themselves? If we're talking about reasonable grounds to test, like none. If I have reasonable grounds, I'm testing you every single time. There's no like, oh, this time I'll let it go and I'm not going to test you. The only situation where I'm not going to test somebody when I have reasonable grounds is if they admit to me they were using, because then there's no need for me to go and test them. They already told me they did it.
I have some clients that have the oral fluid testing on site, and they said just having that there has created a need to not test.
Yeah.
Because
Yeah.
as soon as they know that they're about to be tested, they're often are like, just never mind, I'll tell the truth about it. So.
Right. And I'll give a caveat to what I just said. Like some employers will have really specific policies about, well, if you have this level in your system, then it's not considered impaired. Or if you have that level in your system, it's going to be so high that we're just going to go straight to termination instead of something else. Like if you have a specific need to know what the level is in somebody's system, test them even though they admit to it, because then you need that information for later on down the road. But if you don't have that kind of specific policy and it's just, hey, we violated the policy, I'm going to decide what level of disciplinary action to take, why test? They already admitted it.
Okay. Great. So sort of in follow-up to that, let's say we believe we have reasonable suspicion. What are the steps that we take?
Best practice, right, is to document, well, why do you think you have reasonable grounds that to point to the fact that this person is impaired on site? And documenting it can be pretty hard, right? What I usually suggest is to have maybe some sort of checklist to kind of help you. And is it okay if I throw it up real quick? I've got a sample that we can provide after this presentation. Let's see, share screen. Host has disabled participant screen sharing.
Oh, so sorry.
It's all right.
I could probably do that too.
I don't have the updated checklist. We'll just send it out after for it.
I think I can get you, make you a co-host.
Great.
Nope.
No. All right. Well, we'll send it after. I'll tell you, I've got basically something that looks kind of like a 3-page checklist that helps you kind of think through, well, why is it that I have this feeling that this person is impaired? And some of the things on the list are like, I observed this person using, distributing, or in possession of drugs or alcohol, or I observed this person consuming it. Or this person was reported to be in violation of some aspect of our policy by a reliable person, right? And it even goes on to like physical indicators, glassy eyes, dilated pupils, constricted pupils, heavy eyelids, slurred speech, right? And it kind of goes on, and it helps you just kind of think through the different things that are giving you that sense that you think it's related to drugs or alcohol. So best practice number 1, document it. Whether you use a checklist or you just make a note on your own, either way, it's totally fine. Second best practice is getting somebody else's take on it too. Somebody else being another member of the management team, could be HR, right? Talk to that person and say, hey, you know, I think this person might be impaired. This is what I'm seeing. Would you maybe go observe for yourself and see if you're observing anything like that too? Or am I just being hypersensitive about this? Do you have to have the second opinion? No. Is it nice to have? Sure, because then it's not all on you, right? If anybody questions it after the fact, there are 2 people who personally observed this behavior. If that second person goes in, they interact with the person, or they maybe just observe this person from a distance and they're observing some of these same behaviors, and you both concur, yeah, you know, I think that might be what it is. Then you've got that documentation and you're ready to go, and you can meet with that person in private Let them know that you have reasonable grounds to believe they might be impaired at work. These are the specific observations that you and or this other person, has observed today, and that you've decided you'd like to take them for a reasonable grounds test. You don't allow them to drive because you think they're impaired. Don't let them drive. You need to take them to the collection site if you're going off site. And that's it. Nice and easy. I
Well,
have a few things in the chat.
talk through, Heidi, real quick. So what are the considerations that we should think about if we are going to take someone to a lab, right? So we have heard, and Pam has told me some horror stories of situations gone very wrong when someone gets in the car with the person who's impaired. Pam, didn't you say at one point they had a employee who actually jumped out of the moving car on the way to the lab, right? So, I mean, there are things to take into consideration.
Right. They had agreed to go. Yes, I'll go to the lab. And then halfway through, they must have decided in their inebriated or impaired state that this was not a good idea. So they changed their mind and hopped out of the car while it was going. So that's like a worst case story.
Yeah, there isn't a whole lot you can do to prevent that from happening, but there are some things that you could do to kind of promote safety generally, right? One thing you could do is before you ever take this person to testing, see if they're willing to admit to engaging in the conduct, right? If I sit down and I have this conversation and I tell them pretty plainly, like, this is what I observed, this is why I think you might be impaired at work, I'll ask the open-ended question, is there anything you want to tell me? And see what they say. If they say something along the lines of, yeah, I did. Here's what happened. Depending on my policy, if my policy doesn't require them to test at a certain threshold, I might just say, all right, in that case, I'm not going to test you. We'll move forward with disciplinary action. I don't want you working the rest of the day today. We'll call Lyft or Uber or taxi to get you home. You can arrange to get your car later, or I'll send a manager to drive you home, and we'll deal with it that way. And they're less likely, because it's a less escalated situation, to cause problems since they're going home. If they don't admit to it, and we really do need to go test. Structurally, if it's the kind of situation where you could do an on-site test and you don't have to drive anywhere, that's a little bit safer. That's nice. If you've got to go on site, think about who you're asking to take this person to the on-site testing location and how comfortable that person is going to be dealing with somebody who's potentially really high in their car with them, right? It's okay to have two managers go together with this person, just in case you need, somebody to drive, somebody to pay attention to the person who's drunk or inebriated in some way. That's fine too. But work that out in advance. Then be sensitive to things like protection for the person who is under the influence and protection for the person who is asked to take the employee to the testing facility, in both sides, right? In the sense of, if you've got a male employee who's very uncomfortable being alone with a female employee who's under the influence because of a fear that they're going to be accused of engaging in wrongdoing, then definitely send somebody else with them.
Yeah.
Conversely, right, if you're thinking, well, I'm worried about my female employee who might be under the influence and somebody taking advantage of them, do not send that person that you don't trust with your inebriated employee. Only send people that you trust.
Yeah.
You're taking these employees who are in vulnerable situations.
Yeah. And Heidi, you mentioned before it definitely needs to be someone on the management team. A fellow employee is not an option, or should not be an option.
Yeah. Right. Always management.
Yeah. Okay.
Can I go back to Kathy's question if we have a minute? I wondered if Kathy might have been asking too about like last chance agreements when you said how many chances do they get? Were you maybe also thinking about, how long do you, if this keeps happening, how long do you keep working with that person?
Well, that is kind of what I was wondering. I mean, it does happen, and sometimes it's a one-off, sometimes it's not, but I guess it depends. I was just wondering if there's any protocol, because sometimes, when you're putting somebody on a, writing somebody up, you have to give them 3 chances. Now, I think being inebriated or high is like one and done, but I just wasn't sure if there was any kind of protocol with that.
There's no requirement to be one and done or requirement to be, okay, 3 chances and you're out. The requirement is that you treat all similarly situated employees in a similar fashion, right? So if your organization is the kind that, let's say, provides services to homeless youth who are in who are struggling with abuse and addiction, themselves, I probably wouldn't give a lot of latitude to my staff who's working with that population, right? One and done because of the vulnerable nature of the population. If I'm working in, let's say the cannabis industry, that's the industry that we're in, and my staff is high on something other than cannabis, would I want to give them a whole lot of latitude? No, because there's a lot of illegal drugs out there. But if they were, let's say, drunk, they came in drunk one time, is there a little bit more leeway? I mean, maybe because of your industry. Should you give a lot of leeway? Probably not, but there's more than if in the first instance, right? So for the employer, the most important thing is to figure out what standard makes the most sense for what you do. If you're DOL regulated because you drive truck all over the place, you don't have much room. Otherwise, if you're, I don't know, architects working in an office or receptionists working in an office, and it's an instance of marijuana one time, maybe a little bit more latitude, but not a whole lot. And I see another question, by having Uber or Lyft pick up, if something happens during the ride, is the employer responsible? I mean, they generally wouldn't be. Generally, it's going to be that Uber or Lyft driver, right? Because we're talking about if something were to happen and it's some sort of tort action, right? If the Lyft driver themselves engaged in misconduct, like that's where that action's going to go. If the Uber or Lyft driver got into a car accident and the employee was injured in that instance, whoever is at fault for the accident is probably going to be the first target. Does that mean that the employee couldn't try to point the finger at the employer? No, I mean, people sue people for all sorts of things all the time. Are they going to win that suit is a totally different question. It's less likely you're going to win that suit. But if you are worried, right, you want to be particularly careful. Then if you don't want to drive the employee home yourself, you could send a manager with the Uber or Lyft driver and have them sit there and then ride back after they're done dropping off.
The one thing we didn't talk about that I think we were going to this time, and we're getting close to the end, but depending on how much time you guys have, was the policy and putting that into place first. Right?
Actually, the policy is next time. We talk more about drug-free workplace and what that
Nice.
really means. But one of the things I just really quickly did want to touch on was, I think a lot of people struggle with, if I'm in an organization that has HR and then the direct managers, like whose responsibility really is it? And I think, Heidi, when we talked about this before as well, like your explanation of who do you go to, right? Who's ultimately responsible for dealing with the employee? I think that would be really helpful for people to hear.
Absolutely. So legal standpoint, whoever is the representative of the employer, it could be either HR or the manager, is the one having this conversation with the employee. But from a practical standpoint, and an HR standpoint, whoever has the best relationship with that employee should be the one having the conversation, right? It's already a charged situation. When you bring it up, the employee, if they're not completely totally high and strung out and drunk, is still going to understand what's going on in front of them, and they're going to feel pretty bad about it. So if you've got a good employee or even a mediocre employee, and you value that relationship, and you're not thinking immediately, you're out the door, trying to have the conversation in a kind, empathetic manner is important. And so whoever that employee trusts more, whether it's HR or it's their manager, that person should be the one doing the talking because they have the rapport, right? It's okay to have a second person in the room. Just be aware of the fact that the more managers you have in the room having this conversation, the smaller that employee feels, the more scared that employee feels. And we're trying to de-escalate the situation so you don't have the jumping out of the car situation, right? So make it quick, direct to the point, with the person who has the best rapport with that particular employee, and the mindset of trying to help them get through this process before you even start thinking about disciplinary action.
And there is a question, Heidi, it says, while supervising the employee waiting for the Uber driver to pick up the employee on site, the employee tried to run off and jump the fence to his car. Are employers allowed to take the keys?
Oh no. Okay, so I'm going to flip this and say, hypothetically, if this happened, would it be advisable to take the employee's keys away? And the answer is no, it is not, right? Because it's the employee's property, right? Anytime you're talking about taking somebody else's property, you're opening the door to what we'd call a conversion kind of loss, a theft, a civil theft kind of a suit, right? You don't want to be in the situation where you physically prevent somebody from going anywhere they want to go. And you don't want to be in a situation where you're taking any property that is owned by somebody else away from them, right? Because we're not law enforcement. We don't have the right to do that. In the first instance of physically stopping somebody from going where they want to go, that's not a good situation for HR or management to be in any instance, and sets up a potential option for that person to file a different kind of lawsuit. So if you're faced with this kind of situation where an employee maybe isn't totally with it, they're trying to get away from you, use your words, right? Please come back. This isn't safe. I'm just trying to protect you. Be careful. There are cars that way. It's not safe for you to drive right now. Please don't do that. Think about other people who are driving out on the road. Think about other people that might get hurt right now. Let me help you. Do everything you can verbally to try to convince them, but don't physically get in the way.
Would you then call the police? Would you feel that would be to say, I know there's someone who's about to drive or who is driving inebriated? Would you do that, or would you hold off on that?
Depends on how strong my suspicion was,
Yeah.
right? So if I personally observed that this person was drinking at lunch and they had 3 or 4 drinks, and I could smell it off them, I knew this person was drunk. Yeah, I'd probably call the authorities at that point. But if it was just that I've got somebody else who told me they think this person is drunk, and I talked to the person, and maybe they slurred their speech a little bit, but I couldn't smell anything, and they completely denied it. And the person who told me wasn't able to give me a whole lot of detail other than, yeah, they saw this person have 1 drink at lunch. So I'm not really sure they're actually drunk. I'm probably not going to call the authorities with something like that.
Right. Okay, well, we are at time for this session. Does anyone else have any questions? We can stick around for a few minutes. I hope you'll join us next week. We will get a little more into, what should your, I guess, best practice around drug-free or drug policies in the workplace. sample wording, sort of best practice of what should be included. We're also going to talk about options. So do you have to send them to the lab? You know, what are some on-site options? What's available to us? And I think after next session, you'll walk away with a guideline of here's some options for testing once it gets to that point. So if there's no other questions, we will say thank you very much again for joining us, and hopefully we will see you guys next Thursday, same time, same place. Great. Thank you very much.
And
I guess I'll shut this down and check in with you guys in a minute, okay?
What, Tara, did you have any additional questions? Oh, I show someone still in, but maybe not.